Hello everyone, welcome to the U.S. Immigration. As 2025 comes to an end, many families who have been waiting months and, in some cases, years are asking the same quiet but urgent question: what will happen next year? After a period filled with slow movement, shifting timelines, stricter reviews, and emotional uncertainty, people filing family-based green card applications want to know whether 2026 will finally bring relief or whether the waiting will continue for spouses, parents, children, and siblings separated by borders. This isn't just a policy discussion, it's about being together, building stability, and finally moving forward with life. In this video, we'll walk through what families can realistically expect from family-based green card processing in 2026 based on confirmed USCIS trends, visa availability, consular processing patterns, and policy directions already in place as we move into the new year. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now, let's get into the video. To understand what 2026 may look like, it's important to start with where family-based green card processing stands at the end of 2025. USCIS has made selective progress this year, particularly in cases involving immediate relatives of U.S. citizens. Many I-30 petitions filed in earlier years finally moved forward, and some adjustment of status applications were approved faster than expected toward the end of the year. At the same time, preference-based family categories continue to face long waits due to statutory visa limits, leaving many families stuck despite USCIS completing its part of the process. Heading into 2026, this basic structure does not change. The law governing family-based immigration remains the same unless Congress acts, and as of now, there is no passed legislation that increases visa numbers or removes per-country limits. That means processing speed in 2026 will continue to depend heavily on visa availability, not just how fast USCIS works internally. For many applicants, especially in the F2A, F3, and F4 categories, the Visa Bulletin will remain the single most important factor shaping timelines. One area where families may notice change in 2026 is how cases are reviewed. USCIS has clearly shifted towards stricter front-end screening. Officers are now more likely to deny applications that are missing documents, use outdated forms, or contain inconsistent information rather than issuing requests for evidence. This trend is expected to continue into 2026. For families, this means preparation will matter more than ever. Well-documented cases may move more smoothly, while even small mistakes could cause serious delays or denials. Marriage-based green cards will remain a major focus in 2026. USCIS has openly stated that fraud prevention in marriage cases is a priority and, officers are being trained to apply more uniform standards nationwide. This doesn't mean genuine couples should be afraid, but it does mean interviews, evidence review, and, timelines may feel more intense. Couples should expect closer examination of shared finances, joint residence, communication history, and long-term intent. Some interview waivers may still occur, but they are likely to remain limited. For families applying through consular processing, 2026 will likely bring mixed experiences. The National Visa Center has improved document review times compared to earlier years, and honestly, that progress may continue. However, embassy interview capacity remains uneven around the world. Some consulates are moving faster, while others continue to struggle with staffing shortages, security screening requirements, and high demand. As a result, families should expect interview wait times to vary significantly depending on location, even when cases are documentarily qualified. Another important factor for 2026 is financial sponsorship. USCIS and the State Department are applying affidavit of support rules more strictly, particularly when sponsors live abroad, have unstable income, or rely on joint sponsors. While the legal standards have not changed, enforcement has become more consistent. In 2026, families should expect a much closer review of tax transcripts, employment stability, and proof of U.S. domicile. And, sponsors should really be prepared to clearly demonstrate both their ability and intent to support the immigrant. Travel and adjustment of status cases inside the United States will also require more caution in 2026. Coordination between USCIS and border agencies has increased, and applicants with pending cases may face more questioning when traveling internationally. Advanced parole remains valid, but officers are definitely paying closer attention to travel history, prior overstays, and compliance with status. This isn't exactly a new rule, but it's an area where enforcement consistency is increasing. For lawful permanent residents sponsoring family members, 2026 will likely feel slower than for U.S. citizen sponsors. Preference categories for green card holders are still capped, and Visa Bulletin movement in these categories has been limited unless Congress acts to reform the system. So, yeah, these structural delays will continue. Families in these categories should prepare for longer waits and avoid relying on unofficial predictions. It's also important to address what families should not expect in 2026. There is no confirmed plan to eliminate family-based immigration, there is no new law ending spousal or parent petitions, and there is no policy allowing USCIS to arbitrarily revoke green cards from law-abiding families. What is changing is not the existence of family immigration, but the level of scrutiny, documentation, and procedural discipline required to succeed. As 2026 approaches, USCIS is clearly moving toward a system that favors accuracy over flexibility. Faster decisions are possible, but only for cases that are complete, consistent, and well-supported. For families, this means, taking time to prepare filings carefully, responding quickly to agency requests, and avoiding assumptions that issues will be overlooked. Looking ahead, 2026 is unlikely to be a dramatic turning point, but it may be a more predictable one for some families. Immediate relatives of U.S. citizens may see steadier progress. While preference categories will continue to depend on visa numbers and consular capacity, the families who are best prepared emotionally and administratively will be in the strongest position to move forward. As always, we will continue to follow USCIS updates, Visa Bulletin changes, NVC trends and policy developments closely, and bring you clear, accurate information as it becomes available. That's all we have for this bulletin. The U.S. Immigration Hub channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2 work visas such as L1A, L1B and H1B student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5 and family immigrant visas.